Mr.
The Honourable Simon Power.
Chairman, I think after 10 years gestation, it would be remiss of me not to make a contribution on a range of issues that have arisen, but in particular to comment on the SOP in my name recommending a series of amendments to the Committee of the Whole House after pretty substantive discussions with a range of political parties over a reasonable period of time. Before I get on to those points, Mr. Chairman, I should just notify the Committee of the Whole House that I withdraw the amendment on supplementary order paper number 283 to new subsection 277 subsection 10 or subclause 10 that is to be inserted into the Principal Act by Schedule 3. I've been advised that this is a simple overlap between those two subsections and it's just a matter to tidy up on the way through. What is worth reflecting on is that after something like 7 discussion papers, a Law Commission report, an exposure draft bill, 6 months at a select committee, numerous interactions with the legal profession, the judiciary, and just about anybody else who had an interest in this bill. The bill came out of select committee with quite a number of changes made to it after what can only be described as a comprehensive due diligence process. It became apparent, though, that there still remained some concern from some quarters of the House about a range of issues that they were still requiring some amendment to. Remarkably, the issues seemed similar to a number of parties, and so I was happy to sit down with them all and work our way through it. As part of that process, it became apparent about halfway through those discussions that the legislation probably could have been advanced on a small majority. And at that time, it occurred to me that because the changes had been in gestation for such a long period of time, because they were to fundamentally alter the way the criminal justice system operated probably the first time in 40 or 50 years on this magnitude, that it was worthwhile to pause and engage, if you'll excuse the rugby pun during the Rugby World Cup, pause, I did much touch, pause, engage, to pause and engage and talk to other political parties to see if there was a way through this process. Now, my thanks go to John Boscawen and the ACT Party, who approached those negotiations absolutely in good faith. We had a range of discussions about issues which I have no doubt genuinely concerned the ACT Party's position on a number of those. And I want to thank publicly John Boscawen for the way he conducted those negotiations with me and for the way he worked within his own caucus to see those negotiations end up where we are today. Also want to thank Peter Dunn from the United Future Party for his very constructive and determined advocacy on a number of points, and the Māori Party, who also made clear to me very early on 2 or 3 key areas of objection they had, and I was pleased that the negotiations with other political parties in the House were able to relieve them of those concerns, and then they too were able to pledge their support for the progression of this legislation. Also want to thank the Labour Party and a couple of people in that regard. First of all, and I know probably deny it, but I actually know how important this piece of legislation was to the Honourable Rick Barker, and I actually know that he spent a considerable amount of time as Minister of Courts trying to push this thing along. And all I can say to that member is probably of anybody else in the House, he knows how I feel. Because this is a huge piece of work, and I was not going to let it come unstitched at the 11th hour because there were Mr Chairman, there were three or four, well slightly more than that actually, 5 or 6 areas where agreement could not be reached. And I have to say that the way that the Labour Party, and in particular Charles Chauvel, conducted himself in negotiating these matters with me, I was very satisfied with. Look, in the nature of negotiations under MMP, particularly when you're trying to find a broad consensus beyond just a bare majority, means not everybody or not every party is going to get everything they want. And the truth is that probably applied to every party in these negotiations, not the least of which was the National Party, who had and has, I guess, slightly different views around what the right to silence is and actually what issues in dispute are. But nonetheless, we are where we are, and I said publicly throughout this process that I would be practical and pragmatic about those discussions, and I believe the government was. And Mr Chairman, here we are today, with broad agreement from the second largest party in the Parliament, from the ACT Party, from the Māori Party, from United Future, and I haven't given up on the Greens just yet, because I'm going to address Kennedy Graham's concerns, and like he asking me to reconsider the jury trial threshold, which I have to advise him in good faith I will not do at this point, and the government will not do at this point. I hope to be able to persuade him over the course of the next couple of calls that this bill is worth supporting, and I intend to give that my best shot over the next 6 or 7 minutes. First of all, it is worth the committee just reflecting briefly on what supplementary order paper in my name does, where the compromises have been made and how much common ground we have come to. The SOP amends the bill to retain a shorter 6-month limitation period for the least serious offences. It prescribes safeguards for defendants by circumscribing when the courts are able to proceed in the absence of the defendant, an issue that I know was particularly of concern to Mr Biscown. It removes the provisions requiring defendants to identify before trial issues in dispute, not the particulars, not what was actually going to be argued, but just issues in dispute, and remove the ability for a fact finder to draw an adverse inference from a failure to identify issues in dispute. And of course, it restricted circumstances in which cost orders could be made and simplified the miscarriage of justice test. Now, unless I've read it wrongly, the Green Party support all of that in one form or another, unless I've read it wrongly. The outstanding issue for the Green Party, I guess the big hurdle for them, seems to be this jury trial threshold issue. Before I get on to addressing that directly, I want to just sow a seed in the mind of committee members here today that now that those issues have been resolved, what effect this bill will have on victims, on witnesses, on court staff, on jurors and all those others who are in the court system. The number of sitting hours saved will be 9,360 hours. That is a vast reduction from the original bill, which saw 16,000 sitting hours being saved in our court system. That's the nature of the system that we work in. The number of court events saved before the agreement was 43,000. Following the supplementary order paper in my name is now 36,650 individual court events saved. People able to get on with their lives, to move through the criminal justice system with 36,000 less court events. Cases that no longer need to be designated for a jury trial, previously was somewhere between 1,000 and 1,400, is now between 750 and 1,200. Time to dispose of judge alone or summary trials saved, previously 5 to 6 weeks, here back to about 3 to 5 weeks. So that's not too much of a loss. With respect to time to dispose of a trial saved in the district court, Mr. Chairman, in a district court was 13 weeks, now 6 to 9 weeks. Now 6 to 9 weeks. I'll come back to why that's significant. The savings were originally in the zone of $29 million, now back to about 23 odd. So why does that time to disposal and the number of jury trials saved matter? I want to talk about that in the context of this change to the threshold, because this is why the change in the jury trial threshold matters. And I just want to spend a bit of time on that. The specification in the Attorney General's Bora report of a 3-month threshold for a jury trial, that was, as the case is now and will be until this bill is passed, quote, has had a profoundly negative effect on the conduct of criminal litigation in this country, causing serious delays in the criminal justice system, which may raise far more serious concerns about access to justice. Goes on to say the proposed increase in the jury threshold, this was when it was to 3 years, so I'm not arguing about the substantive point, would not put New Zealand in breach of its international obligations, a point acknowledged by the Green Party, nor would it place defendants in this country at any comparative disadvantage to those in comparable jurisdictions, noting that Canada, in my opinion, the most liberal one of the most liberal common law jurisdictions in the world, provides a threshold for jury trials and imprisonment for 5 years or more. Mr. Chairman, there is very little historic justification for the current 3-month threshold, which was originally based on the UK threshold at the time the provision was enacted in New Zealand. But of course this no longer represents the UK position. And whilst the right to a jury trial, and this comes back to the time to disposal issue, whilst the right to a jury trial is an important aspect of the criminal justice system, the critical issue identified by the Attorney General is not the threshold at which the trial is elected, but whether the right to a fair trial is preserved. And most significantly, and I really urge the Green Party to think about this, most significantly, another important constitutional right under the New Zealand Bill of Rights Act is the right to be tried without undue delay. The right to be tried without undue delay. And that's why the time to disposal matters. When the absolute adherence to one right impacts or results in a negative impact on another, as I think the Green Party are putting the position, consideration must be given to the greater public good in redressing the balance to better ensure adherence to principles underpinning both rights. Not just one right, but both rights. And in this case, we're not just talking about the right to a jury trial, we are talking fundamentally about the right for those people to be tried without undue delay. And when the court system and the justice system clogs itself up at the bottom end of the pipeline without addressing what should be really occurring in that justice system, with game playing and toing and froing occurring at the front end of the process, that right to receive a trial without undue delay is put at risk. And I would ask the Committee of the Whole to give that right under the Bill of Rights Act some serious consideration. And remember here that the criminal justice system and this legislation is not just about the rights of the defendant. There are other participants in the criminal justice system, witnesses, victims, jurors and the like, who find themselves in that system through no fault of their own, and we as legislators have a responsibility when we pass legislation to have their interests in mind as much as the rights of the defendant.